We are here talking with attorney Jim Howell, who has agreed to be interviewed regarding the recent Supreme Court decision finding the caps on non-economic damages unconstitutional. Jim, can you visit with us a little bit about this?
Sure. Uh, the best way to start probably is to go back historically to the 70s and 80s when all of this started. There was a rumor that the medical malpractice insurance premiums in Kansas were so high that healthcare providers, predominantly doctors, were leaving the state to other states where they thought the insurance premiums were cheaper. Also, those that were in residency programs that might come back to Kansas were not coming because they heard that the insurance rates were too high. So it's interesting because, as we found later, none of that was really true, but at the time it certainly was a strong enough rumor that the legislature felt that it needed to act, and it did. It enacted some what we call tort reform legislation, which is basically laws that were trying to curb issues involving verdicts in different types of personal injury cases. What the legislature did was basically pass a number of laws as part of this tort reform package, which included a creation of a state-run insurance company that they hoped would result in lower premiums because it was not a commercial insurance company. It was actually run by the state and supported by those who were healthcare providers in the state of Kansas paying premiums. So they enacted that. They put minimum requirements that you had to have. Before, there was no requirement you had to have insurance. But under the tort reform package, now everybody who got a verdict in a medical malpractice case, for example, would have insurance available through them through this healthcare stabilization fund that was set up as part of the tort reform package. It made doctors have insurance that otherwise they wouldn't necessarily have to have. Also, along with that, during the tort reform period, they enacted what are referred to as non-economic caps on damages. The idea was that along with making insurance available for everybody should they get a verdict or settle a medical malpractice case, that they would agree that they would have damages taken away from them, which was basically, I think, unconstitutional, and as I'll later talk about, we certainly went that direction to try to correct it. But basically, the cap on non-economic damages that was passed were things like pain and suffering, mental anguish, loss of enjoyment of life, those sorts of things that had a physical and mental impact on you as a result of an injury were capped at $250,000. So, for example, if medical malpractice was committed upon you and you settled your case, or you received a verdict for $500,000 for this loss of enjoyment of life, mental anguish, and you were, say, a 24-year-old paraplegic as a result of this, all of the rest of your life, all of those damages that you have, non-economic damages, would be capped at $250,000. So if a jury came back and awarded you $500,000, the court would literally just line through that verdict amount and put down $250,000, and that's what you were entitled to collect. So that seemed patently unfair. That was forced upon the citizens of the state of Kansas, who had no say in it. In particular, it was pushed by insurance companies, physicians, hospitals, the Chamber of Commerce. These caps were all pushed by them in that belief that the insurance premiums were too high and it was going to impact your health care in the long run, because these physicians and doctors, there'd be a mass exodus from the state. So that was the purpose behind the legislation that was passed. Now, if we turn back the clock quite some time back to the late 1800s, what we find is Kansas adopted the Kansas Constitution. Within the Constitution is Section 5 and Section 18 Bill of Rights. And what those basically say is that the citizens of Kansas, under its Constitution, have an inviolate right to a jury trial. Now, that inviolate right to a jury trial included not only asking for a jury trial and getting one, but the entire process all the way to a verdict being awarded by the jury to the injured plaintiff, and his ability to take that award and try to collect it. That's been there since 1859, 1869. It was the late 1800s when we adopted that. So the question became, is this really fair for the legislature to impose upon the citizens of Kansas a cap on non-economic damages when you have a constitutional right to collect all your damages? So for decades, persons like me and other plaintiffs' lawyers have been fighting this battle, trying to find the caps unconstitutional under our Constitution, that it's just not right. You have an inviolate right to a jury trial, to keep all of the damages are awarded, and to pursue collection of those. So the battle occurs mainly in the Court of Appeals. We've tried legislative issues and to no avail, but we're in the Court of Appeals in the Kansas Supreme Court fighting this, trying to get the appellate courts to recognize that these caps were unconstitutional. They violated your constitutional right to a jury trial and your constitutional right to collect your remedy, to have a remedy and collect it, a full amount of it. So finally, and we probably have had, I would say, I'd estimate at least 10 Supreme Court cases that have dealt with this issue, and we have consistently lost. The Supreme Court and the Court of Appeals have consistently found that no, it doesn't violate the Kansas Constitution. It's okay to have these caps. Well, finally, recently, we had some success in the recent case of Hilburn versus Enterprise. The courts found the caps unconstitutional, finally, after decades of fighting this issue. We now have justice. Now, when you get an award of $500,000 or $800,000 for a catastrophic injury, for your pain, your suffering, your mental anguish, your loss of enjoyment of life, the whole shebang in those areas, you actually get to have it, be awarded it, and collect it without the court doing anything. There are no more caps. Justice is finally done. Like I said, I've been a willing participant for decades in this, and I'm certainly a participant in the cases, most of the cases that have been looking at this issue of constitutionality, and also actively involved with Tom Warner, whose case it was that made all this possible, and his client, Amy Hilburn, for her allowing us to go forward with this when she'd gotten a verdict and collect part of it under the current state of the law, and all those persons who were involved in this battle and this fight. So finally, justice has been done, and now when you get a jury award, you can collect it all, or at least have the right to collect it all, without the court's interference or the legislature's interference with trying to cap some of your damages.